Okay, it's Mark with CareQuest Solutions. We are live once again. Excited to have a continuing series of Just Ask Seth with Seth Meyerson Law. Very proud to have them join the show for this series that we're doing. It's going to be a really good one tonight. We're going to be talking on powers of attorney. Anne, our co-host, is not able to join, so we'll miss her. She's having some technical issues today, and she will be back ASAP. So let me count this down and bring Seth and Julie Watts in, and let's get the show going. All right, Seth and Julie, welcome back to the show. How you guys been doing?
Good to see you, Mark.
You too, buddy. How about you, Julie? Doing okay?
Doing great. Thank you for asking.
Good deal. All right. Well, again, it's going to be a good show tonight. So on Just Ask Seth, we're going to be going over powers of attorney, and there is more than just one, right, Seth?
Yes, there are.
Yeah. So let's kick it off and start with this one. What is a special or a limited power of attorney?
A limited power of attorney is a narrow power of attorney. It lets you do certain things and not do certain things. The most common place I see limited power of attorneys is for the sale of a house. Often people give their realtors a limited power of attorney to sell their house.
Okay.
So power of attorney is something that can allow another person to act for you.
And once that particular task is done, it obviously is dissolved automatically.
It may have a narrow date range, and it should, and it will have a very specific power or statement of powers.
Gotcha. Okay. Well, what is a general power of attorney?
Well, a general power of attorney, all general power of attorneys aren't made equal, actually. So when I think of a general power of attorney, I think of something that's pretty comprehensive. Now, we look at other powers of attorney or the Georgia statutory power of attorney, and often it's not sufficient for our needs, especially if we're doing Medicaid planning and things like that. Someone's become disabled, and we want to protect that person's or that family's assets. We need to really be able to shuffle the deck.
Okay. Speaking of Medicare and Medicaid, I think open enrollment's about to start the 15th of this month. So we have Julie Lunsford coming on again tomorrow to talk on that. But when you mentioned that, Seth, I wanted to mention that is coming up because a lot of people are not aware there's a window of time for all that. So what is a durable power of attorney?
A durable power of attorney is that's a very useful feature, and most of the powers of attorney we help execute contain that. A durable power of attorney is a power of attorney that remains even when the grantor of the power of attorney becomes disabled.
Okay. And on the general, that goes away when the person dies or whatever.
Most general powers, we do a very comprehensive power of attorney that I would refer to as general. It is also a durable power of attorney. For our applications, estate planning and elder law kind of applications, almost every power of attorney we do is durable.
Okay.
And some are more limited than others, and if we're trying to prepare somebody for protecting assets in a Medicaid situation, we do a very comprehensive power of attorney we call enhanced, and it will let the holder do anything that the grantor can do.
Okay. I was going to ask this later, but I'm going to ask Julie now because Julie, she's the intake manager, as you can see, and when the calls come in, everybody will be speaking to Julie. So when someone calls inquiring about any of these powers of attorney, Julie, what would be the steps that will happen from that call?
So I find out where they're located. I want to speak with the principal or the person that's wanting to designate their financial surrogate or their healthcare agent or their attorney in fact. Um, you know, do a little interview with them and find out where they're located, see if they're able to come visit us in the office and set up arrangements for them to come in and talk with Seth about that. We want to
Okay.
find out how they're doing, their health, what their immediate concerns are and what their long-term concerns are.
Okay. And what's the general time of putting something together, Seth? Like when you identify all of the answers to the questions, how long does it take to put together a power of attorney? Are they all different in the lengths of time that it takes?
Well, a power of attorney by itself is can be very quick. We usually
Okay.
include powers of attorney, both healthcare and financial, as part of an estate plan.
Okay.
So as part of an estate plan, 2 to 3 weeks. If you come in
Gotcha.
and you need a power of attorney immediately, or sometimes we talk to people where their spouse is beginning to lose capacity, we want to make sure that the well spouse retains the ability to make decisions for the potentially disabled spouse. We do them pretty quickly. We need the spouse who is losing capacity to still be competent in order to do a power of attorney. The law says that you have to have the capability, the mental capability to contract to be able to execute your own power of attorney. So this is the kind of thing you need to do before someone is disabled.
And that's what I was fixing to say. And that gets back to that's the talking point. And it really has to be brought up every time we do a show is don't wait, because things can happen: stroke, heart attack, car accident, on and on and on that goes. So I think that gets back. And that's why we always ask any client that we have, have they spoke to an elder law attorney? And if not, want to send them your way, because I think that those consults are important to see what needs to be put in place. Does there need to be estate planning in place to have all this done? Because when it happens, it's too late. And I know you deal with that all the time. To people come in and I'm sure you hear this a lot. We talked about it last year and we just never got around to it, and now they're facing, crisis. And when Julie, when you sent this, I had no clue. Like, what is a springing power of attorney? I've never heard of that.
I'll tell you what it is, and then I'll tell you why we don't usually recommend it. Springing power of attorney is a power of attorney that doesn't grant powers until a precondition is met. A precondition like 2 doctors say you're disabled, or a certain date. So a springing power of attorney is a power of attorney that springs into action when a certain condition's met. Now, the reason we don't recommend that is because if somebody's disabled, it can take a long time to get them formally adjudicated as disabled or get 2 doctors to agree in writing that they're disabled. So what we usually do, I'm going to tell a couple of jokes, but what we usually do is we tell clients to maintain, if your power of attorney, if you have a concern about it being live and somebody having that power while you're still well, we tell them, look, keep physical control of your power of attorney. And there are 2 ways that someone might get your power of attorney. So the first way is you say, well, look, if you come and get my power of attorney and I know you did it, you're too early. Okay. It's a joke, allegedly. Okay. So, and the second way is you say, look, I'm having trouble managing my affairs here. So those are the 2 ways that someone might get a hold of a power of attorney, and how the person granting it might maintain control of it until it's needed. I also call that the nightstand method, or the desk drawer method. It's in my desk drawer, John. Come get it.
Come and get it.
But if you don't come and get it too early. If I know you did it, you're too early. Okay. All right. So that's one way to avoid a springing power of attorney, a power of attorney that doesn't come into effect until 2 doctors say that I'm incompetent. So powers of attorney can be convenient. between spouses. It lets one spouse work in Texas and the other one sell the home in Georgia. So,
okay.
but the real purpose of powers of attorney is when something bad happens, when somebody loses capacity.
Okay. And speaking of what we had said earlier, the importance of getting things done ahead of time, it would be this one as an example. What is a medical or a healthcare power of attorney, and how do they come into play? And kind of stress the importance of having these done like now.
So, the financial, in my opinion, the financial power of attorney is much more important than a medical one. But a medical
Okay.
one does, it does some important things. Let's talk about that. So, in Georgia, a medical power of attorney is one document. It's a statutory form. It's called an advance directive, and it does three things. You select who it is you want to be your healthcare power of attorney. That's the person who can make decisions for you regarding your healthcare if you can't.
Mm-hmm.
The other aspect is the living will, is often called the living will. It's just part of this advanced directive. In the living will, you specify how much care you'd like at the end of your life.
Okay.
So you might say, there's two choices or two basic choices. There's some variation you can add, but to simplify, one of the choices is, hey, keep me alive no matter what. Okay, and this only matters when you can't communicate, because if you could communicate, the physicians will just ask you. So if you can't communicate and you're in a terminal state, which means you'll die within a short amount of time, or you're in a vegetative state and your prognosis is you won't get better, and two physicians agree that you're in these states, then your medical power of attorney or your living will apply, and you can say, hey, keep me alive no matter what, or you can use a more reasonable standard, which is allow my natural death to occur, give me food and fluids as necessary to administer pain medicine. I think that's a more reasonable approach. One of the big things that a living will does is it actually maintains some family harmony. If dad goes in the hospital and all the children are wondering what to do, and one of them says, look, we need to put him out. All the doctors said he's not getting better. And that can tear families apart. But the power of attorney, what that will let the holder do is say, look, dad said he wanted to go if he was like this, in writing. So it's not me making the decision. Dad made this decision, and so when we can let dad go, and it preserves harmony between the family, between siblings, all. So that's one of the big benefits. And the third thing, and the final thing a power of attorney does, is you nominate someone, a healthcare, to be your guardian, should one need to be appointed. So the probate court appoints a guardian for you if you can't manage your own affairs. It's a conservator with a financial power of attorney, and when you go to court, or when somebody goes to court to appoint a guardian for you, that selection is given heavy weight. Who you chose to be your guardian when you were well. So, but also as a practical note, if you've done a financial power of attorney and a healthcare power of attorney, it's unlikely that your family is going to need to go to the trouble and expense of going to a probate court to have a guardian and a conservator appointed for you. You've already given people what they need.
Yeah. I tell you, there's a lot that goes into dying, isn't it? You got to protect.
Well, sure. It's not always that bad. Sometimes people lose capacity for a short amount of time,
and recover.
And the power of attorney comes in handy. But often it's aging, and it's unfortunately it's a one-way trip towards losing capacity.
Yeah. Well, you touched on the living will. Go a little bit further on advanced treatment directive. What is that?
So advanced directive is how much care you would like at the end of your life. The key points here are by specifying that ahead of time, you eliminate some of the possibility for family conflict.
Okay.
The two big choices are keep me alive no matter what. I'm heavily paraphrasing. Or
Yeah.
allow my natural death to occur, provide
Yeah, do
me-
not resuscitate or whatever.
do
Yeah.
not resuscitate's a whole nother thing. I tell that's
That
an
is?
order from that's an order from a doctor. So
Okay.
that's very tactical. That means if my heart stops, do not resuscitate. Now,
Okay.
the advanced directive would cover that if one of those two conditions were met. The two conditions
Okay.
being terminal state or vegetative state, not going to get better, obviously, and can't communicate. Whoa.
You are getting attacked by a bunch of bees.
I don't know what happened. I think maybe the light's getting lower. Well, let me take care of that.
He's got attacked by a bunch of bees.
Oh,
There he is.
right.
Hey.
Now I'm going to be shining.
There you go.
So, advanced directive. So, that's the big benefit of an advanced directive is family harmony. And also if you want someone else to make your medical decisions besides your next of kin, you need one, or that person that you want to make those decisions is going to be shut out. If they're not married to you, what if you have a partner and you're not married? You're going to be playing second fiddle to relatives, even though you may have lived with this person for 20 years. So it's important. These documents are important to do before, as you pointed out, important to do before bad things happen. And unfortunately, ultimately, bad things happen to us all.
I've got someone says I got a tough question and I'm asking them to send it. So shoot that on, Kim. And let's see. Here's one that's going to be a good talking point is how do you obtain a power of attorney for an elderly parent?
Well, with the elderly parent's consent. So the elderly parent needs to be able to have capacity still to contract, and then then you go see an attorney, or you could use their state forms for it, but ours would be more comprehensive than is available using the statutory form. And you go see an attorney, and and if mom or dad is still competent, they can sign a power of attorney that doesn't take away the parent's right, but it does allow someone else to make decisions as well, and to do things like pay bills or apply for benefits or sign taxes.
So if they're not able, like say it's too late, they're incapacitated, they had a stroke, they're incoherent, is it too late?
It's difficult. So if they are truly not capable, then it's unethical to do a power of attorney. You might argue that, dad is good in the mornings. And if I explain it to him 3 times, he can consent. And he did have the capacity to contract. As a practical matter, if no one objects, you can do almost anything. But if you've got relatives that are fighting over resources and you don't want it. In order for power of attorney to fail, it'd have to be challenged. Where do you challenge the power of attorney? In court.
Okay. All right. What qualities would someone be looking for when selecting a healthcare agent?
Well, you want the world's best mom. So you want, a lot of times when you bring your spouse to, a lot of us bring spouses to the doctor's appointments. I do sometimes. And, but if you're already bringing somebody to the appointment, that's probably the person who should be your medical power of attorney. I mean, that's the person you're consulting with, or It helps you make those decisions when you're fit. They might be the one to make decisions when you're not.
Yeah. This will be a fun one. What qualities is someone looking for when selecting the financial power of attorney? I'm
Someone
sure
who
you see.
won't. It'd be good if they don't steal from you. That would be good.
I tell you, I bet you see a lot of that stuff. Julie,
We
I bet you get
litigate.
phone calls of stuff all the time of people like, you're not going to believe this. What am I going to do?
We litigate these issues. So, powers of attorney. So, a lot of times structurally, you can tell when things are going to go well. You got a family, a couple that's been married 40 years, and she already manages his finances. I mean, what's the problem with giving her a power of attorney?
Yeah.
There isn't. So, or you might have a child where you're leaving everything to the child anyway, and the child has your financial power of attorney. Well, I mean, it'd be good if you really can trust them not to take your money early.
Yeah.
But as a practical matter, if she's not stealing or he's not stealing anything, he won't get, so he probably won't do it. And then most people don't steal, okay? But there's enough people to keep lawyers busy.
Yeah. Yeah. This, I'm sure, is a big question people have. Am I losing control by giving someone a power of attorney over them?
All right. So granting someone or executing a power of attorney does not take your rights away. It gives somebody else the ability to do the things that you can do. So the short answer is it could cause some problems if you guys are both out there making decisions in the world, even good decisions, but they're in conflict with each other. That causes problems. Now, if you don't want someone to have your power of attorney, you can revoke it at any time that you're still confident. So,
so at any time, someone can, if they give someone power of attorney and then they decide something happens, whatever, they could terminate it.
They can terminate it. So practically, how do you do that? Well, you're going to need to send copies of that termination to places that matter, places that have your money, or where you have your insurance policy or whatever it is. You also send the revocation, of course, to the person who holds the power of attorney. And if they use your power of attorney after they have notice that you've revoked it, it's fraud. They could be civilly liable and criminally liable.
Okay. Is there anything you'd like to add that we may have not asked or something you thought of? Hang on, let's see. I got a question. Does a durable power of attorney need to be registered? They're in Texas. This person in Texas.
I can't speak for Texas, but many states are similar. Go see your own attorney in Texas. What I'll say is what would happen in Georgia. Okay. In Georgia, you don't need to register your power of attorney. But some acts require that your power of attorney be recorded. For example, if you do a deed for someone, if you are transfer property for the grantor of a power of attorney to you, you need to include a copy of the power of attorney with the deed transfer.
Okay. And like you're saying, that's for Georgia. So
just for Georgia, I imagine that many states have similar rules. I cannot speak to Texas rules. I am not licensed in Texas.
But it's good that you gave the advice of what would be here in Georgia. So hope that helped, Jane. All right, Kim said, should a child's spouse with POA use the estate funds for the person's care or place them in a trust to preserve inheritance, potentially relying on taxpayer-funded programs for care?
Okay, that is a complicated question for a number of reasons. Okay, so Medicare is the long-term care provider of choice for people who are short financial resources. If you transfer assets away from someone, that counts on your application for 5 years. So it's not as simple as just stripping the potential aid recipient of assets. There are lots of interesting strategies to accomplish this and save money for the family, but you can't just gift their assets away. That will not be effective. Don't do that. You need to talk to an elder law attorney before you take action, because it matters. It can affect whether or not your loved one will qualify for benefits, and it'll affect how much of the asset you save. So merely transferring it to a trust or another person isn't going to accomplish what you want. Please go see an elder law attorney.
Good question. Good answer. Thank you for that. Denise says, "Hey, Julie." All right. Well, let me
Hey.
let's see. Make sure I don't put your. There's the information for Seth's office. You will be getting Julie as the point of contact when you call in. I encourage everybody to share this video. There's been some dynamic information in here. And Seth, Julie, Denise, thank you guys for taking the time to do the Just Ask Seth series. It's a treasure trove of valuable information. And I highly encourage anybody that's in the state of Georgia, especially in this area in the South Side, to reach out to Seth's office. They do a fantastic job. They are a great team. So don't hesitate to reach out. As you can see, Seth is more than willing to take the time to answer these questions. And we greatly appreciate it. As far as CareQuest Solutions, we're here to help families with independent, assisted, or memory care, or in-home care, or in-home health. We'll connect the families with the resources they need for all those decisions. But we're always here to make a difference and to matter. That's what this show is about, to get content and resources out there. And companies like Seth is one of the primary examples and reasons for it. And again, I can't thank them enough. So with that said, we'll be announcing the next Just Ask Seth series as part of this ongoing show goes, and we'll come up with the next. Anybody has anything they would like to just ask Seth, give us some ideas, and we'll run it by them and see if we can't do a show on that. Tomorrow's show is on Medicare and Medicaid. We have Jennifer Lunsford joining us again. So as always, thank everybody for supporting the channel. Like, subscribe, share, and watch the show and comment. Thanks, everybody, and we'll catch you next time.
Thanks, Mark.